Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. Listen, this is going to be one for all of our veterans and really everybody. I had a couple of vets come up to me over the weekend. I was doing some presentations down in Vancouver and Camas, and they asked me about some articles that they had read about a huge win for veterans as it relates to preserving their Second Amendment rights. And a lot of them just really had a hard time understanding or connecting the dots because I don't think it had been really well reported. And I don't think they realized just what a massive, massive relief and huge win this is for vets nationwide. If it even doesn't affect you right now, it could affect you later on in life. So this is a huge win for all vets. And I think we should applaud the people who made this happen as well. So today, let's spend a few minutes. Let's connect all the dots, get everyone educated, and let's talk about how many veterans just had their Second Amendment rights saved. You watch the news, you read the headlines, and you know it for yourself. Your community is less safe than it was just a few years ago. So you decided to purchase your first firearm. But like everything else in your life, you wanted to do this lawfully and responsibly. So you trained and trained and trained. You learned the laws of self-defense and all the tactics necessary to protect yourself and your family. To this day, you continue to train, and you now live by the motto that it's better to have it and not need it than need it and not have it. You are prepared for anything, or so you thought. Who are you going to call when it all hits the fan? Who's going to defend you for defending them? Who's going to stand in your corner when you realize that proof beyond a reasonable doubt means one thing in a high school civics class and something altogether different in the real world? Introducing Right to Bear, self-defense coverage that protects you so that you can protect them. With an attorney-answered hotline, you will always get a confidential conversation with your state's attorney. There are no cap limits for either criminal or civil defense. All forms of self-defense are covered, so from a fist to a firearm, you are protected. And you will have some of the nation's most passionate 2A attorneys defending you. And the peace of mind that you will have knowing that Right to Bear is in your corner, well, that's priceless. Listen, I've been in this industry long enough to know two things with absolute certainty. Good lawyers aren't cheap, and cheap lawyers aren't good. So visit my friends today at protectwithbear.com, and if you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, so listen, what we're going to talk about today is a lesson that really can be learned for all of us here. And that is sometimes the most innocuous piece of legislation, sometimes the most innocuous little rulemaking has a very, very nefarious intent, and it's oftentimes way too late before we realize it. Because when I trace the history here, you're going to see that this problem really started in 1968. It really got exasperated in the early 1970s and has persisted to this date and affects every single United States veteran. So this was a cause that was well worth fighting for. There were numerous organizations that had been fighting for many, many years. The NRA was one of them here, and I want to be honest about that. They did a very good job of continually putting pressure, and finally there has been legislative and congressional action taken. Now, let me get you educated as to how this works so you can understand, especially for you vets, what a huge, huge benefit this is. Okay, in 1968, we passed the Gun Control Act of 1968. One of the things under federal law then is it made it unlawful for any individual to own or possess a firearm if they had been adjudicated as mentally defective, okay? So let's remember that. That's the term, adjudicated as mentally defective. Now, they didn't really come around to defining that, but therein lies the beginning of the problem. Now, in 1973, under the case of United States v. Harrell, an appellate court did look into an attempt to define what adjudicated as mentally defective meant, and they ruled it meant the following. The term mental defective refers to a person who has never possessed a normal degree of intellectual capacity and does not refer generally to mental illness or mental insanity. Okay, has never possessed a normal degree of intellectual capacity. That was the definition. Now enter the VA. Now the VA does a lot of things, but in general what they do is they manage benefits for veterans who have disabilities due to their service to our country. And although most of those benefits are dispersed and distributed directly to the vet himself, occasionally the VA will make a finding that that person is not really capable of handling their finances, and they will then issue the benefits to a fiduciary, someone usually directly in the house with the vet, the spouse, a child, somebody like that, who can then make sure that those disbursements are used to care for the veteran. But you see, then in 1979, the ATF, in a rulemaking order, sound familiar? Yeah, they decided that they needed to interpret what adjudicated as mental defective meant, and their interpretation stated, a finding by determination by a court, board, commission, or other lawful authority that a person, as a result of marked subnormal intelligence or mental illness, incompetency, condition, or disease, lacks the mental capacity to contract or manage his own affairs. All right, so now, according to the ATF, if you can't manage your own affairs, then you are considered to be adjudicated as mentally defective, and then of course you would be precluded from being able to possess a firearm. Okay, now let's fast forward to 1998. Bill Clinton's in the White House at that time, and what does he do? Oh, under executive order, the VA now starts reporting, this is important, to the NICS background check system anytime a veteran's benefits are actually being transferred to a fiduciary, and they're reporting to the NICS background check as if the person has been adjudicated as mentally defective. And that has been going on since 1998. Now, understand that this VA finding that a person has been adjudicated as mentally defective involves no finding whatsoever that the person poses a danger to himself or others, or herself or others. It has no finding necessary to show that they lack a detachment to reality or anything like that. And then this is the most important thing. Determinations are being made simply by VA officials. Is there a hearing? Is there an appeals process? Is there an opportunity to put on your own evidence to show, no, I'm perfectly capable of managing my finances? Absolutely not. Sua sponte, the VA is making this determination. So what does that mean for our veterans? It means that if some bureaucrat in the VA determines that maybe I need to send the monthly checks to the spouse rather than the vet themselves, that then gets reported to the NICS system as if there's been an incompetency finding against this person by a court of law, which then will preclude that veteran, the very individual who served our country, the very individual who put their life on the line for our freedoms, from ever possessing a firearm. And here's the crazy thing. Even if the VA makes that finding, can this person still go out and enter into other binding contracts? Yes. Could they go out and buy a car? Yes. Could they go out and mortgage a home? Yes. Could they go out and theoretically get married again, which is a pretty binding contract as well? They most certainly could. So this is a finding that doesn't really mean much except to the VA and to the NICS background check. Well, thanks to Senator Jon Kennedy and Representative Mike Bost, new language has been added through this appropriations bill that's going to finally stop this insanity once and for all. And kudos to both of those congressmen for doing the right thing. Now, what changes? This is what changes. The new language corrects both problems by prohibiting the VA from reporting beneficiaries to NICS as mental defectives without the order or finding of a judge, magistrate, or other judicial authority of competent jurisdiction that such person is a danger to himself or herself or others. And this is a very simple and accurate solution to a very complicated problem that was honestly put in place during other presidential administrations where the goal was not really about caring for our veterans, but rather disarming Americans, and in this case, disarming the last category of Americans that should ever be disarmed. That, of course, being our veterans. Listen, we'll go ahead and link up all the information down below. Again, kudos to Senator Kennedy and Representative Bost. Fantastic work. If you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box as well. And then finally, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.